All right, we are on the record in the case of Sue Novak versus the State of Wisconsin Department of Corrections. The ERD case number is 2021-00120. The administrative law judge in this matter is Alice DeLeo, DELAO, and a complaint that was filed on January 21st, 2021 with the Equal Rights Division of the Department of Workforce Development. The complainant alleged that the respondent violated the Wisconsin Fair Employment Act by discriminating against her in terms and conditions of employment because of sex and terminating the employment of the complainant because of sex. In an initial determination that was issued on November 9th, 2021, an investigator for the division found that there was probable cause to believe that the respondent violated the WFEA, and this matter was certified to the hearing and mediation section for hearing on the merits of the complaint. And today is March 29th, 2023. We are scheduled for 3 days of hearing. Hopefully we will be done by that time. We were scheduled to start at 9 o'clock. There was some attempt at discussing settlements, but that really didn't work out well. And then mostly we have been having problems with the revised exhibits that the respondents sent in to have them upload in that. And that was at my request that I had wanted the names of inmates to be redacted and to be substituted with initials. And there was some miscommunication between me and the IT people, and then we were having problems with the exhibits. But I believe we have now got this all straightened away. All right, for the complainant, there is an appearance by.
So this is Ben Hitchcock, Cross of Cross Law Firm, appearing for the complainant, Sue Novak.
Okay, and Ms. Novak, you said is going to be appearing at some time during this proceeding today, possibly, but you're going to proceed without her now, correct?
Correct.
Okay, and the respondent is appearing by?
Eric Mullenbach. I'm an attorney with the Department of Corrections, State of Wisconsin.
Judge, I just want to add to the record here that we had Secretary Carr was available.
Okay, we'll do that afterwards. We're not we're doing this now. No.
Right, but he's no longer
Mr. Cross,
here.
Mr. Cross, no.
Yes.
I control the hearing. I get to say what's going on. We will get to that issue. I realize that that is an issue that you want to talk about, but we are doing the introductions now. So,
Okay.
Mr. Mullenbach, could you do that again, please?
Yeah, first name is Eric, last name is Mullenbach, Mullenbach, and I'm an attorney with the State of Wisconsin Department of Corrections.
Okay, and we also have a box here for who else is on here but not on screen.
That's DOC paralegal Angela Riniker.
Okay. So as we were discussing, we are here for a merits hearing. We had discussed settlement. During the settlement discussions, the Secretary of the Department of Corrections was here, Kevin Carr, to discuss settlement, and those settlement discussions are over, and Mr. Carr has left. Is that correct, Mr. Mullenbach?
He's left this, yes, he is available, but he's no longer linked into this hearing.
Okay, so I did not get the impression from you during the pre-hearing that we had just on Friday, today is Wednesday, that there was a problem with producing any of the witnesses that were on the witness list for the parties. So are you telling me that you will not be producing Secretary Carr for testimony today, as we had discussed previously on Friday?
Well, Judge, the issue is we have not received any properly served subpoenas. And, you know, I obviously have a duty to my client, a duty of loyalty to my client, and that certainly does not entail helping my opposing counsel secure his witnesses for his case. I am not refusing to produce Secretary Carr. I would just argue that as of right now, he has not been subpoenaed to appear, and I don't see how Ben Cross has the authority to compel him to appear because there hasn't been a subpoena issued.
He's not compelling him, and I'm not saying he's compelling him. I've just understood there was some agreement between the parties based on the way we talked on Friday that this was going to happen. If you wanted a formal subpoena, did you ever tell Mr. Cross that you wanted that?
I sure did. In fact, he improperly served me subpoenas on March 22nd through email. There was several problems with the attempt that he with the service, including that some of the individuals, or at least one of them, was not a DOC employee, so I couldn't even accept the subpoena on that employee or on that individual's behalf. I did let Mr. Carr know that I was willing to accept service, personal service, on behalf of all the 12 individuals that he wanted to subpoena.
Mr. Cross, no, not Mr. Carr.
Oh, I'm sorry, Mr. Cross. Yeah, I indicated to Mr. Cross that I was willing to accept service on behalf of all 12 individuals, so we didn't have to serve them at their respective institutions. And that was on March 22nd that I let him know that. Mr. Cross apparently decided that subpoenas weren't needed. I have no idea why. I'm sure he'll explain that. But as of right now, I do not have any properly served subpoenas for any current DOC employees in my possession. And yeah, I guess I'll just leave it at that.
And what were you anticipating the properly served subpoenas to be, since he emailed them to you and you decided that wasn't sufficient? And under normal circumstances, of course, an email is not sufficient, but we have had much more lax, communications and that on this type of issues during the pandemic. And so I'm not quite sure what it is. Did you instruct or at least let Mr. Cross know what it is you were looking for in terms of a properly served subpoena, and when did you do so?
I did. Like I said, I responded to him at 2:44 p.m. on March 22nd, letting him know that for all 12 DOC employees, he could serve me or the Office of Legal Counsel here at Central Office in Madison. We would accept service of all 12 of those employees, so we didn't have to serve them at their respective institutions. In fact, Mr. Cross just sent the email with my response. I made it very clear what I expected. He had roughly a work week, to get those subpoenas served, and they haven't been served.
So you wanted them to be physically sent or taken to the DOC office where you work and given to you. Is that correct?
I wanted them to be served properly. That's correct, Judge.
Okay. Mr. Cross?
Okay, so let's just read out this email that he agrees that he sent to me. He says, "Good afternoon. These subpoenas contain a number of deficiencies. First and most importantly, they have not been served properly." Then he goes on to say, "Nonetheless, I do recognize that the hearing is only a few days away, and therefore I am willing to accept your subpoenas for all the DOC employees rather than requiring you to personally serve them at their respective institutions. Please feel free to call me if you have any questions." So we want to be clear that attached to this is subpoenas that were sent to him, signed by me, and sent to his office there. So at no time did he say that he required it to be faxed or personally served to him. And that it was very clear to me that in this case, like in many other cases, and you'll notice this issue didn't come up because we've had DOC hearings, that is to say, in the Leapsky matter, for example, we were able to have this similar arrangement, and that's exactly what happened, that we sent them subpoenas and that they agreed to. But it's the key language here. It says, "I am willing to accept." Okay? And that conveys to me that he is willing to accept the subpoenas that we sent to him. There's nothing conditional about that, saying, "I am willing to accept these subpoenas if you serve them on me." It says, rather than requiring you to personally serve them. So there's no question, he doesn't disagree that he made an offer and that we accepted it. What he's saying is that we didn't understand the secret meaning of his offer, which meant that he wanted them personally served on him. Now, I also want to be clear that he and I have had several communications, not only including the pre-hearing conference in which we all discussed the witnesses. We've had several communications back and forth, including written emails to Mr. Mullenbach here about we will see Mr. Carr here at this hearing, and that what order I expected him to appear. We had several discussions about witnesses. And he is unable on this exact subject because you asked us to do that. And then we did. I called him up on my client's dime, and we talked to him about the order of witnesses as recently as Monday because you asked us to do that. So, yes, there's a lot of bad faith here, Judge. I mean, not only, I mean, to rest on the technical language of the statute is bad faith when he has written this statement here saying, nonetheless, I do recognize that the hearing is only a few days away, and therefore I am willing to accept your subpoenas for all the DOC employees that rather than requiring you to personally serve them at their respective institutions. So if that has some other meaning, then I'm willing to accept these subpoenas that you gave us, that's secret to him, okay. But nevertheless, we relied on those statements and did not go through the time and expense are now here today, and more of our precious time is being wasted. It's 10:48, and we still haven't had a single witness on. And really,
I understand your position. Okay, Mr. Mullenbach, are you going to agree to provide these witnesses or not?
I still, let me just make one thing clear. Attorney Cross only read a portion of the email. In my email, I said, in sum, I cannot accept service of these subpoenas. I then followed up with another email the next day saying, I'm not going to be physically in the office, so when you personally serve these subpoenas, you can leave them with one of the paralegals. I think that Attorney Cross's contention that I gave him the indication that he was able to serve these subpoenas via email is disingenuous at best. That is not the case. I made it very clear to him that that was not the case. And he had time to personally serve us with the subpoenas. He just chose not to. I have no idea why. I made it very clear that personal service was required. He sent me the subpoenas via email. I expressly told him, and it says in quotes, in sum, I cannot accept service of these subpoenas. I'm not sure how much more clear I could be.
Okay.
And I let him know that I couldn't.
I want to talk. Okay, so Mr. Mullenbach, I understand that there was a second email. Okay, so, but when we talked, you and I and Mr. Cross, you never brought this up. I would have expected in the WebEx pre-hearing, one of the whole reasons is so that we get ready for hearing, that you would have said to me at that time, well, we had originally agreed that we would, produce, some of these witnesses, but, we've been waiting for personal service and that hasn't happened. So I don't think we will be producing these people. That was the time to bring that up, not at the hearing, at the very beginning of the hearing, when we are all set to go for 3 days.
Well, I understand that, Judge, but at that point in time, he still had a couple of days to serve us with those subpoenas. So
you should have told us that was your expectation. I would have expected to hear that from you so that I would know that that was a possible problem and we could resolve it at the WebEx pre-hearing, which is the whole reason for this thing. I'm not saying that you don't have a right to say that, to stand on this premise. If you want to, you can. But if you're going to insist that Mr. Cross had to serve these people personally, and you're not going to go forward now, I am going to just say, fine, we'll just cancel this hearing, reschedule for another time, because I am not going to, say he can't have these people testify because you made a request that you then did not reiterate at any point, particularly when you were talking to me and to Mr. Cross on Friday to let us know that. I mean, we talked about this, and it was, to me, I got the same impression that Mr. Cross had, that you had made an agreement and you were going to provide these witnesses. And I do not see that happening now. And if you're not going to do it, then I am not going to penalize the complainant by this. I am going to just cancel this hearing, and we will give the opportunity for Mr. Cross to dot his I's and serve these subpoenas. And then we can, reschedule this at some other time, which I don't think anybody really wants. But if that's what you want to do, we can do that. So that's my response.
Can I respond to that? Can I respond to that, please? Judge, I understand your position. I'm not insisting that we, delay this hearing. We're all ready to go today. But again, I'm not sure that I had to raise at the preliminary hearing, at the pre-hearing conference, that Mr. Cross is expected to comply with the law. Now, again, he knows how to serve a subpoena. He's required to serve subpoenas in order to secure his witnesses at the hearing. And I made it very clear to Mr. Cross that he was required to serve those subpoenas in person as required by law. Now, that being said, I just want to make that record and we can move forward if, I'm not refusing to call anybody. I just want to put that on the record in the event that this does go for an appeal.
Okay, so, but you will be producing Mr. Carr and the other witnesses that we previously understood were going to be appearing from the respondent that Mr. Cross was going to call.
So long as they're also on his pre-hearing disclosures, yes, I would have no problem with that. Obviously, subject to the same objections that they haven't been subpoenaed.
Fine, you've got that continuing objection, and we will continue down with this case. All right, so. One second here. I want to make sure there's no problem that I need to deal with here. No, we're good. Okay, good. All right, so now that we've wasted time on that, let's go on with this hearing. As I said, there was no ability to settle this matter. I certainly urge the parties to continue to try to resolve this matter. It's not going to get any cheaper by going on. Mr. Cross, you said that you want your first witness to be Secretary Carr. Is that
Secretary
correct?
Carr, please. Yeah, let's get him.
Okay.
Yeah, he's right down the hall, so I'll just let him know to log back on, Judge. I'll be right back, okay?
All right, should we take a break and do that? How long is this going to take?
I mean, 5-10 minutes is my guess.
Well, then let's take a break, come back in 10 minutes, okay?
Okay.
Just mute yourself, and I'm going to stop the video, mute yourself, and stop your video.
Okay.